Thank you very much. Minister Lametti, in your October 2nd reading speech, you stated this in providing justification to exclude assisted suicide eligibility where mental illness is the sole underlying condition. Quote, the trajectory of mental illness is more difficult to predict than most of physical illnesses, that spontaneous improvement is possible, and that a desire to die and an impaired perception of one's circumstances are symptoms themselves of some mental illnesses. Quote, I agree, and over the last decade, I have become a mental health advocate due to my personal circumstance. During the Bill C-14 debate, I said this, and I reiterate it now. We must provide real options for those struggling with mental illness, not arm them with the means to more easily access the devastating final choice of suicide. Those who endure psychological suffering need our support, our resources, and our promise that we will never give up on them, even when they can see no other option but to give up on themselves. So, Minister Lametti, please take 1 minute of the time that I'm allotted here to defend the constitutionality of that provision to exclude those with mental illness from Bill C-7. I contend that this preserves hope for them.
Thank you very much, Senator, for your question. When I was speaking in the House of Commons, as in fact my opening remarks today emphasized, this is the opinion that some medical experts have advanced. It underlines the seriousness of mental illness. It underlines the fact that we must try to give hope, and we must push the medical profession to provide as many options to people as suffering from mental illnesses as we possibly can. And so to that extent, I agree with a great deal of what you've said. We do think this bill is constitutional because of the very narrow focus, as I just said in my answer to Senator Carignan, that there is a very precise focus to this exclusion, and coupled with the uncertainty in the medical profession about the parameters, if you will, or how to apply medical assistance in dying to people whose sole condition is a mental illness, we need to be careful. And so this will be studied. You will get a chance, others will get a chance in the parliamentary review to weigh in. Other experts will get a chance to weigh in. I can't predict what the outcome of that will be, but of that discussion will be. But for the time being, we feel that this law is constitutional and this exclusion is constitutional.
Thank you. Minister Lametti, on this one, because I have a further question, I'm just looking for a yes or no confirmation here. Is it correct that you appointed Christine Baudouin, the Quebec Superior Court judge who rendered the Truchon decision? You appointed her to the Quebec Court of Appeal last week. Is that right?
Yes, I did elevate her along with another judge. As with all my elevations and all my appointments, there was a vast degree of consultation within the court itself, and there was a wide degree of support for that elevation. And there are also judges who expressed an interest. So she was amongst the judges that expressed an interest.
Thank you. And Minister Lametti, 4 years ago, we in the Senate were carefully and thoroughly studying your government's first assisted suicide bill. The studies were thorough, the debate was extensive, there were many experts heard, and several amendments proposed. And now, only 3 years later, that Bill C-14 legislation was challenged in front of a lower court, and your government did not make a single attempt to defend your own legislation. Minister, I'm sure you'd agree it's extremely unusual for the government of Canada not to even try to defend their own substantial law, not a previous government, but your own government, and so soon thereafter. And especially after the only C-14 constitutionality judgment was from one judge from the lowest level court, not a court of appeal, not the Supreme Court of Canada, where many judges rule. So before you were appointed to the cabinet, Minister Lametti, you voted against Bill C-14, believing it did not go far enough. So is that why you did not appeal this lower court decision? Is it because you got the answer you wanted?
Senator Batters, you have run out of time. I'll put you on the second round. Senator, I will now go on to Senator Batters. I don't know if you remember Senator Batters' question. You had so many, but I was not able to let you answer it. Senator Batters, do you want to quickly restate your question so that the minister can answer.
I'll just state the end of it. Minister, before you were appointed to the cabinet, you voted against Bill C-14, believing that it did not go far enough. And I'm wondering if that's why you did not appeal this lower court decision with Truchon. Is it because you got the answer you wanted?
Definitely not. And again, I thank you for the question. You're in fact right. I did believe that C-14 at the time, as a member of Parliament, did not go far enough. But as Minister of Justice, I stated publicly on a number of occasions that the bill had been passed into law and that I respected the parliamentary process and that I would defend that decision. What happened with Truchon? What happened? There were other cases, Senator, in Canada, in particular that of Julia Lam in British Columbia, which was also proceeding, but which was put in abeyance after the Truchon decision. As well as we had information of other cases potentially going to be launched. And what that was reflective of, and what guided our decision to not seek an appeal decision, was a real fundamental change in Canadian society since 2016. There was a widespread acceptance of MAID. The Canadian Medical Association has become one of the most positive, proactive partners with respect to MAID across Canada, and medical practitioners who are seeing this, some are doing palliative care and MAID, and they are seeing this as a spectrum of services that they can offer to people in a very compassionate, empathetic way. And there's a wide degree of acceptance for MAID. We knew that we were getting that kind of information, and we based the decision in Truchon not only on constitutional grounds and what we believed to be was the right decision in that case, but also the fact that Canadian society had changed quite a bit since 2016 with respect to the acceptance of MAID, and that it was time to move to next steps.